I'm Sheila Rule, moderator of the In Our Name conference. On a beautiful August weekend, an array of advocates, professionals, and the general public came together to discuss the state of our criminal justice system. What you're about to experience is a compelling mix of thoughts, ideas, and stories that will help us all to reframe our thinking about crime and violence in America so that we can move forward toward a just and fair system for all.
All right, so let's see if we can have a good time talking about a tough topic. Parole in the state of New York. They said to me, what do you think a good parole board ought to be like? So I did some thinking about it, and I considered what we currently have that many of you are familiar with. We got Earl Eichelberger out there. Point him out to you because he used to be on the board as well. So when you get mad and want to throw bricks, don't throw them all at me, throw some at him. But you talk about what would a what would a good parole board be? And I thought about that, and I said, the ingredients. The first thing that you have to have. First, you have to agree that parole makes sense. Some people say, no, we ought to get rid of parole boards. I've been saying that for years. A number of jurisdictions did get rid of their boards. We used to have a parole board at the federal level, United States Parole Commission. The commission still exists for a few remaining old law cases, but they must be down to maybe one commissioner. That's all they need. They went to sentencing guidelines many years ago, going all the way back to Ted Kennedy got that law passed to get rid of parole at the federal level. They thought they abolished parole in the state of California all the way back in 1977, but they still have the Board of Prison Terms, and they're dealing with all the lifers. I thought they would go out of business because how many lifers could there be? But California went to their 3 strikes law. They got more lifers than they can handle. So the board is very, very busy, and they can't even use their commissioners. They have to hire people to go and make the release determinations. We got our board here in the state of New York. Their role as a part of the criminal justice process has decreased over the years. Sentencing changes in the state of New York, and we got a schizophrenic state when it comes to sentencing. We don't really know what we like. So we currently have definite sentences for those sent to local jails. We have determinate sentences for those convicted of violent offenses. And we have indeterminate sentences for the worst offenders. Those are the lifers. And every now and then the legislature will create a new sentence that would get you life. Not one of the old ones, new ones. You look in Article 130, you'll see some of those that have come on the books in the last few years. And given the imagination of our legislature, because they all read the funny paper, which is called the Daily News, and that's how they figure out what they need to legislate for, and they certainly will create some new laws. That's what they do every year. They create new laws, finding new crimes and giving them new punishments. But we've got these 3 forms of sentencing, and we still have a prominent position, prominent posture in place in our criminal justice process for our parole board. So I said, well, if we believe in the basic concept of parole, that an offender who offended and was hopefully legally prosecuted and found guilty and sentenced appropriately to a prison period, then somebody ought to be screening him, her, prior to their release. That somebody would be a parole board. Why would they screen him? Well, maybe the guy gave some indication while he was serving time that he shouldn't be paroled. Now, the concept wasn't that you'd never be paroled unless your behavior in prison was such that they just couldn't get you out because you wouldn't let it happen. But we don't see that too often because we see that most of the guys get the message And they say, you know, if you're going to keep screwing around in here, the board's going to use that against you, and that'll be a reason to hold you, so don't do that. So we're living in a time where I think many inmates, especially our lifers, learned that years ago. And you got so many guys who've got life maxes and are subject to the discretion of the board who come to the board and haven't had a misbehavior report in 10+ years. And to the extent that the department has programs that they could participate in, they've done them all, done the best they could. Some of them have created programs. Some of them, one of them in this room, have even gotten into lawyering in prison and as inmates, bringing lawsuits on behalf of other inmates, and have gotten things changed through the courts in the state of New York. They do pretty good. So we would think those guys don't have any real reason why they should be held and continued in prison, but we know that happens. So we don't want a parole board that would continue people in prison when there's no reason for them to be there. That seems to make sense. How do we get that? I think we have to have a strong governor. A governor who says, whether he understands it or she understands it or not, I'm going to support the parole process. This is a state agency. I'm the chief executive, and we're going to have a parole process that works. Then that governor, whoever he or she may be, has got to get, as parole board chairman, somebody who's prepared to roll up his or her sleeves and go to work. There's nothing wrong, in my opinion, with selecting parole board members, so long as they meet the minimum quals that are currently set in the statute, if they come from this party or that party. There's nothing wrong with having someone on a parole board who's had law enforcement experience or social work experience. There's nothing wrong with that. But I think as the residents and people of the state of New York, we want this parole board, wherever they come from in terms of their political backgrounds, political histories, ideologies, and so on, to become a functioning board. Now, they're not always going to agree with each other, but they should move toward consensus determinations. They should be deciding as a board how people can get released. That's what they're doing in their meetings when they're not meeting with inmates. How do people win release? And their chief executive, the board chairman, chairwoman, should be leading that discussion and moving that group toward these consensus determinations, because we want them to pretty much come to the point where their decisions are predictable. Predictable by whom? By everybody. You should know, if you're a citizen paying taxes and supporting these people by paying their salaries, what to expect from them. You shouldn't be concerned that they're going to make dopey decisions, or they're going to make decisions that make no sense in that they hold people and cause us to continue to support them in prisons for no discernible good reason. Seriousness of the offense is not a discernible good reason. All right? You have to have something more than that. Now, many of us thought John Carr from the New York Law Journal last year, after the legislation was passed to force the board to use, instead of the guidelines that they weren't using anyway, a risk assessment, he was about to party. He said, look, it's happened. It's coming. It's going to be good. They're not going to be using seriousness of the offense anymore. John Carr's articles in the Law Journal got to the inmates around the system, and they still write to us believing that that's the new law. And of course it's not. Now, was it the intent of the legislature that the board look hard at risk? Wasn't it their intention? Gave the board the authority to go out and find an appropriate risk assessment instrument? They came up with North Point. North Point says in their advertisements that they're good. They say they've done this in other jurisdictions. I haven't seen anything in writing. I don't read everything. So I might be out in left field. But I haven't seen anything in writing that touts North Point as a way to go for a decision-making body like a parole board in the state of New York. But anyway, I said to John Carr, because we corresponded and we talked, I said, I don't think so. I don't think so. I think maybe we're going in a good direction, but we ain't going to get there through this. And lo and behold, I'm in Otisville 2-3 months ago, and a lifer comes up to me. We had a little meeting with the guys. They got a lot of lifers in Otisville. But anyway, this guy comes up and he says, Mr. Hammock, can I show you this? I said, yes, sir. He says, it's my risk assessment instrument. I said, oh, let me see that. So I look it over. This guy's a low risk for reoffense. Low risk for reoffense. I said, what kind of sentence are you doing? He said, I'm doing 20 to life. How many years you got in? 26. You been to the board a few times? Yeah, I know most of them now. I'm getting to know them better. I said, oh. What happened when you went to your last board? He said, well, they gave me this risk assessment instrument. I went into the board panel. I got hit with 2 years. He said, how does that work? I said, beats the heck out of me. I don't know. So obviously, the legislature, who's the guy here from Cure, New York? Yeah, there you are. So you put in your thing there the comments that were made by Jeffrey R. Obry talking about that legislation. Now, it seemed to me when you wrote that in Cure, New York, he was still scratching his head. But I think you and others of us should be telling him, stop scratching your head. You need to get back into the legislative areas there and get a hold of Dean Skelos and let him know that this is not about bad government. This is about a fair system. You know? So back to my idea. We get that consensus board. They now tell everybody this is what we're going to do. And this is how we're going to do it. They put it out there. For those of us who are interested and care, we can comment. And we can say, we disagree with that. Or, we like this, but we don't like that. And then the board can internalize all of that information and come to a conclusion as to how it's going to go. Now, they can't keep listening to everything you got to say. There's got to come a shut-off time. When they say we're going to do what we got to do, we're the ones charged with the responsibility. We can't have our job dictated to. It's only the Daily News that does that now. You know? We got to make our own decisions. And so they make that decision and make it public. And who do they tell? They tell judges. Now, when I was on the board, long time ago, when I was on the board, I thought we ought to talk to judges. So we used to do that. We had meetings with Supreme Court judges. We used to talk to them about the parole process and how it operated. They talked to us about the sentencing decisions that they were supposed to make. We were aware of the fact that more often than not, they don't make the sentencing determinations. They're made by assistant DAs. Since People Against Farrar in the state of New York, it's the DAs who control sentencing. You know, as citizens, are we happy with that? I'm a practicing attorney. I'm not happy with it. I'm not happy with it because who am I dealing with as an assistant district attorney? All too often, I'm dealing with somebody who's a career prosecutor. Is that a good idea? I don't think so. You know why I don't think so? I was a prosecutor more than once. I started my thing as a lawyer, 1966, New York County DA's office, signed to the Homicide Bureau, investigating, presenting to the grand jury homicide matters, and trying those cases. I thought I was doing God's work, and I worked hard at it. I thought others along with me were doing the same thing. But we didn't figure to be there for the rest of our lives. We only had a 4-year commitment. We didn't have a commitment to retirement. As an assistant district attorney trying murder cases, how can you do that day in, day out for years and years and years? Go to the Queen's DA's office. Look where all the senior trial lawyers are. They're not trying cases. They are supervisors. They're supposed to be training. To me, it looked like they're just getting fat. I mean, I'm not trying to put the Queen's DA's office down. You can go to any of them. You see the same darn thing. Is it wrong to be a career prosecutor? In some instances, no. But in many instances, it's not the way to go. They become, they won't like me saying this, but it's true. They're narrow-minded. How can they be otherwise? They live in a closed environment. Who do they talk to on a regular basis? Witnesses? Not really. They talk to cops. Is it bad to be a cop? Of course not. We need cops. But you got to understand, sometimes they have an agenda. The agenda may be because they can't work overtime, they can't follow up on the case. I ain't doing this work. I'm not going to ask this question. I'm not going to go there. Let the DA figure it out. It may not be a high-quality arrest. It's a uniform arrest anyway, and I'm supposed to get grade money, so the supervisor told me I'm taking credit for the collar even though I wasn't there. That's the way policing operates. That's the way cases get investigated. And when you have assistant district attorneys who are inexperienced with the way of the world, being outside of the law school environment and outside of the prosecutorial office where they function, you end up with the kind of justice we have today. There's a lawyer that everybody ought to know him, Joel Rudin. I want to say this guy is like Superman. Superman. Every time I turn around, Joel's in the papers. Why is he in the papers? Because he found another darn case. Or maybe a guy doing time in prison found Joel Rudin and said, I've been telling everybody year in, year out, I didn't do this. I didn't do this. You know? I've been telling people, this evidence against me, it's the wrong dude. It's not me. Joel Rudin, he goes into court, he gets his investigators, he spends his time, he works up the case. I don't know how he does it. I think, like I say, I think he's Superman. And he comes up with enough evidence to show prosecutorial misconduct. Now, do I believe assistant DAs go to law school, graduate, go into the DA's office because they want to do wrong? No, I don't believe that. Do they do wrong? You bet your bottom buck. Prosecutorial misconduct goes on and on and on. And like in the last article, which is just a week or so ago, on Joel Rudin getting somebody else out of prison. R-U-D-I-N. First name Joel, J-O-E-L. He's in Manhattan. He's very good. A little expensive. I'm cheaper, but he's a little expensive. These assistant DAs, they need training, they need oversight. They need to have a feel for criminal justice. They need to understand people. They really don't. I got a case right now. I mean, is the guy guilty? I don't know. He says he's innocent. Did the little girl say he did it? Yes, she did. But how come she waited 2 years to say it? I don't know. If I ask the DA, is she going to tell me? How do I know? How do pleas get taken? Very often, because the DA who's dealing with the defense lawyer on the case doesn't know that much about the case, but he knows he's got a case. They got an indictment. Somebody testified in a grand jury. There's enough. What do you do when your client doesn't have money for an investigator? Even if you have an investigator, is there something to investigate? You know, so we got these kinds of issues. If we have a parole board that knows what it's doing and knows why it's doing what it's doing and says to the judges, this is what we're doing and this is how we're doing it. When you send them down the pike to me, this is what you can expect. And say that to the DAs. You know, I'm reminded when they used to attack the parole board when I was on the board, those were the good old days, because I'm sure you can't do that, can't do today what I did then. But I remember there was a DA up in the Bronx named Mario Marola. And there was one of these typical cases that comes up where some guy had been paroled and he goes out and he does ugly. And when he does ugly, he gets in the papers. The papers are all tuned into who had him last. And if the parole board had him last, they're responsible for this new crime. They let him go. They knew. They should have known. He shouldn't have been let go. So we had a case like that. It was a Bronx case. Marola, who was a gentleman and a really nice man that I really came to like, almost love and appreciate. Wasn't much of a lawyer, but he was a good guy. Okay? And Mario went on the attack in the papers. So I said, fix this guy. So I go down to the courthouse. I pull the file on this particular guy. I look at the indictment. He's got 24 counts in the indictment, 24 felony counts in his indictment. Mario's office pleads this guy out to 2 counts. Mario's office gives this guy a very attractive sentence. Now, do I know? Maybe those other 22 counts were bogus. I don't know, but they were all felony counts. There had to be sufficient evidence in the grand jury to support those counts in the indictment, so there was something there. As we used to say in the trade, there's a little smoke, maybe there's some fire, okay? But I said, hey, he's the prosecutor. He's the elected prosecutor in the county. He's the one who decides who gets prosecuted. He has a constitutional authority to make that decision. All of them do. All 62 of them do. They make the decisions on who gets prosecuted. Because if they decide you're not getting prosecuted, it ain't going to happen. If they decide you are, you're in. Okay? So when he and his minions decided to plead that case out for the sentence that this young man received, I said, and I believe it to be true, he sent the parole board a message. This is all this case is worth. This is an appropriate sentence. The DA controlled the sentence. He's the one that told the court, this is what we'll take. Defense lawyers pride themselves, I got you a good deal. You only get as good as the DA gives you, never any better. That's all you can get. Because they've got the chance to say, you ain't getting no more. So you may think you're wonderful as a criminal defense lawyer, but you got to remember that you never get better than they give you. So once they gave us that, I said, the board got your message, Mr. Marola. You told us that this guy only needed to be in for the minimum. Because if you thought he should have been in for longer, you would have seen to it that he got more time. So we followed your lead, listened to you, respected your position, and we parole him. He goes out and does ugly. You're accusing us? Take your own heat, my man. Take your heat. You know, it ain't ours. And that's the way I felt it should have been handled, right? So that's what I want. I want a strong board. I want them to make a decision as to what's right and wrong when it comes to the paroling process. I want it to be subject to examination so it passes the test of fairness. I want the decision-making of the board to be consistent so we don't have, as we do today, you know the F-man? Some of you know the F-man on the board today? Well, a few of you do. Oh. I'm calling him the F-man so he can't accuse me of using his name, right? I mean, what do you do with a guy like that? All right, don't answer. But you don't want that kind of thing. You don't want a board member thinking that he or she has to stand up for a position that turns out to be an unpopular decision with somebody else. So whether that board member thinks everybody ought to be released or everybody ought to be denied, that's something that the board has to deal with as a board and get that under control. That's what I feel, you know? Now, what's going to be in the state of New York? I mean, I do think that some of what's happening, some of what needs to happen should come from the board itself. That's basically what I'm saying. And I know the current chairwoman at the board. I only know a few of the board members. I read minutes of the release hearings that they conduct. You know, they're pretty typical. They basically always do the same thing. You know, like we tell clients who are going to go to the board, the crime is the thing. They're going to start out with the crime. So if you go to the board, because you've read the executive law provisions governing parole in the state of New York, and you see all the things they're supposed to consider, the 16 factors now plus the risk assessment instrument, you know, and you check out the parole staff to make sure they don't make too many mistakes in their piece of the thing. You know, you go through all of that, and, you know, I mean, what's going to happen when you go there? None of us seem to be confident that the right thing is going to happen. But I think they're moving in the right direction. I just would like to see more coming from the board itself. Now, I'm not saying that the chairwoman is not doing those things, but I don't see the evidence of it. You know, and I don't see any reason why, as a member of the public, and an interested member of the public, I shouldn't be able to see more evidence of it. I mean, it's almost like the board's in hiding. It's in hiding. The only time they come out of hiding is when they got a cop killer case and the Daily News gets a decision before it's made. How is that? How is that? In my day, we had a word called confidentiality. It no longer exists. Things have changed. You know, maybe you cannot keep some information from the public sector. But dealing with the media is something that the board needs to do. They can't have the entire board do it, but the board's representative ought to be dealing with the media. You can't let them dictate to you your job. You have to dictate to them your job, okay? You have to say, we are the Board of Parole, this is what we believe in, this is what we do, and stand behind it. And like I say, when you see you made a mistake, learn from that mistake and change in order to eliminate that mistake. But to do things the way they are now leaves us all very unhappy. To have the legislature in a haphazard way pushing that you guys do, some of you push members of the legislature to move in a particular direction. You don't feel you can successfully push the Republicans. Criminal justice is everybody's issue. It really is. And we really need to educate some of those on the Republican side in the Senate that it's everybody's issue. It's not about keeping everybody in or letting everybody go. It's about a fair system that works. Nowadays, we know anybody can go to prison. Anybody can go to prison. Look at the kinds and types of people that we've been sending to prison. People who are highly exalted. I'm looking at the news this morning before leaving home to come up here to be with you guys. And I see this Vito Lopez, is that his name? Yeah. Holy Toledo. And then the little guy that was a congressman for a short period of time, Harold Ford Jr., whose father used to be something. Now Harold Ford's a professor at NYU or something, and he's a commentator on Morning Joe on MSNBC in the mornings. He's a Democratic guy. He's supposed to be an Obama supporter. Every now and then he gets a little weak in the knees, but generally speaking, he's there for Obama most of the time. And all the pictures they show of Lopez, who's just about to get booted because Shelley Silver's on his case, there's Harold Ford right there with him, so he has to live that down. But this is, Lopez is not going to prison yet. We don't know anything about that. I'm just saying to you, the types and kinds of people that go to prison, you know, fellow that went to law school when I was doing a little teaching over there, used to be the Democratic County chairman in Brooklyn. You know, he ends up, Joe Hines beat him up 3 times, sent him to prison. Everybody goes to prison. They're entitled to a fair system as well. Everybody has an interest in this. Now, what I would like to do, if you don't mind, I would like to stop talking. I would like to give some of you an opportunity to voice some opinions that you may have or questions, and we can discuss. We are lucky enough to have here in the room Mr. Descovich. He's got a lot of experience in how prisons operate in the state of New York. We got Mr. Langoni here. We got my law partner, Donna Sullivan, here to help us along. We got other interested parties that I've gotten to meet today. We got Mr. Fiorello here. Where did he go? I don't even see him. Oh, there he is. I thought you were sleeping again. We got him here. So let's go. I mean, somebody got something they want to say, a question they want to ask? I don't hear anybody. Oh, here you come. All right.
I'm going to be good in talking to the microphone like they keep asking. I loved everything you said, and the idea of a consistent, strong parole board that works toward making decisions that make sense is just, you know.
I hope it's not pie in the sky.
What?
I hope it's not pie in the sky.
I hope so. But what we've done, a group of us, Sheila Rule was part of it, there were 7 of us that rewrote 259I into a bill that we call the Safe Parole Act. Have you heard about it or seen it?
I don't think so.
Okay. Well, the main thing that we've done in this bill is take out the nature of the crime as one of the reasons that can be used for denial. They could use it for other reasons. They could look at the crime and see how far the person's come from those days, but they can't make it the basis of their denial.
Well, let me ask you this question.
Yes.
You say that. I don't want to be interrupting, but I want to take that point and work
Yeah.
with it just a little bit.
Good.
Okay. If the board saw a particular offender and said, I want to deny you release to the community at this time because of the nature of your offense, that's statement number one. And then they went on to say specific details about that offense, which would clarify what they mean when they say nature of the offense, and which would give you or anyone else reviewing that decision by them pause for thought. Hey, there is something a little unusual about this. Now, I don't want to give you a set of facts, but I hope I'm making my point. So when they simply say nature of the offense, they don't tell us anything. If they say something to us, I'm asking you now, assuming what they said was fact-based.
Yeah.
In other words, it was related to this offender's actual crime, and it seemed to be relevant to a decision to differentiate him from someone else convicted of the same crime. What would you say about that?
Well, I have two thoughts. First of all, they do go into detail about all the crime on all of the denials I've seen.
No, all they do is say
spend
the elements of the crime.
No, they say you stabbed her 13 times, and then you walked away, and then you came back, and you stepped on her foot, and then you did this and that. They go into great detail in all the denials I've been sent. So they do that. But we do not think that...
Just let me say, they did it in yours. They don't do it in the ones I see, but that's neither here nor there.
That's very interesting. We should compare. I'd like to see what's different between our people. But we feel that it really is the nature of the person that's in front of them today. Is that person shown themselves to be ready to come out into society?
All right, so
and
then,
one of the ways you can judge that is by asking them and finding out from them, how have you changed since you committed this crime? Why should we believe that you are ready to come home and not commit a crime? But to go into, it's resentencing when you bring up the crime and say that it would deprecate the seriousness of the crime, it would jeopardize your community. That was decided, we feel, by the judges or by the DAs, as you've informed me, it really is, that set the sentences.
well, the only time a judge really has control over a sentence is when the defendant either goes to trial and loses, then it's judicial sentencing, or the judge is offering a better deal than the DA, and most of the DAs will then force the defendant to plead guilty to every count in the indictment, which creates a problem because sometimes some of those counts that the defendant ends up pleading to he's really not guilty of. So that confuses the parole board, because when they get the sentencing minutes and they see all of these sentences, you know, like in a paper case where these larceny cases or fraud cases or whatever, that tends to be a real problem. But that's the only way a judge can get control, total control over the sentence. But there's no question, I mean, you and I agree, even though we may be talking a little bit differently, that very often with decisions that are being made by the board, it is only rational and reasonable that you call it a resentencing determination. In other words, if the minimum term is supposed to be that amount of time, whether it's the DA or the judge, that those who knew this case, because they investigated it, they were responsible for prosecuting it, and a judge bought into the agreement between defense counsel and the district attorney, so you have all parties, the judge, the DA, and the defendant, agreeing that this is an appropriate sentence, then what you're basically saying is when the guy serves that minimum term, you really should be looking at something that happened after the commission of the crime itself. So we would agree on that?
Yeah.
All right.
I have one other point.
I vote for your law.
What?
I vote for your law.
Great. Thank you. That's on the record, right? I just want to point out that I think the parole board still is operating illegally because they have not, Andrea Evans has not, or her board have not promulgated the rules and regulations that they're mandated to right as to how the board is supposed to be applying the risk and needs assessment in the TAP instrument. And I also understand that they're not using the TAP instrument, even though the law still says they have to. They're going back to using, what is it called, the whatever they're using now before the TAP got implemented. Prison
Well,
status report.
Oh, inmate status report?
Yeah. They're going back to using that. They're tweaking it.
They
so
never
in
really,
two ways, I feel like they're ignoring the law.
well, they never really stopped using the inmate status report. But when you talk about parole, and I know that's where you're focusing, no problem, but if you look over in corrections, you're going to find the same thing. When I say find the same thing, what I'm referring to is this. Things become how the department or parole operates, but there's nothing in writing to support it. They just do it. And like you say, because I was trying desperately for quite a bit of time to get how this risk assessment instrument was supposed to be point scored and what does it mean, how do you interpret it, and what I got back is we don't have it ready yet. We don't have it ready yet. It makes you almost wonder, are they working on it at all? And then you say to yourself, well, how are they being permitted to get away with this? In other words, should I be pressuring them? I really shouldn't have to do this. You know, with all the talk about big government, small government, this government does exist. They are a creature of statute.
Yeah.
Why aren't they doing it?
Yeah.
You know? So is this another New York City Housing Authority? I mean, where they don't have, well, you talk to people in parole, you talk to people in corrections, and you hear things like, we have as much to do now as we had to do 3 years ago, and we're doing it with 30% of the people we had before. So, I mean, do you want to sit down and cry for the state employees? We don't sit down and cry because we're affected. If we do a work release appeal, there's nothing in the regulations that says that they can take 90 days to give you a decision on a work release appeal. But you call Priscilla Ledbetter, who's a very nice lady, and she says, I have 90 days. So you say, where'd you get that from? That's what we do. And I spoke to her on the phone this week about getting these appeals out, and she says, well, I just got 2 new people, but they won't be able to really get going, so I'm up to 5 months now for a decision on work release. You know, is the system falling into the toilet? To some extent they are, but when it comes to the parole board, I don't think it's a lack of resources. I don't think that they have a legitimate basis for not taking care of this. Because between them and Northport, they ought to be able to get this stuff together. And the fact that it's not there makes us all a little suspicious. Well, it makes me suspicious. I don't want to speak. Any other questions, comments?
Yeah.
All right.
One, I just noted when we did this whole study that was in the Cure newsletter for the winter thing of Cheryl Kate, she had 51 testimonies that you commented upon. But people mentioned that they had parole board members spend no more than 4 minutes on a paper, and what I've heard, the guys I've been talking to, is one member of the board will be reading the next case while another person will be talking and has looked at it. And some of the people who I've worked with have said they've never even noticed things that I put in. They never even looked at it, so they're not really reviewing the case. So that's an issue of how great of a review there can be of a case when they're hearing 20 parole hearings within 4 or 5 hours. How much time can they spend on each case? That's the first thing. The other thing to this whole process issue, I know that in Canada, you know, the whole Canadian system has a restorative justice component right from the day one. They have a plan that is supposed to follow people all the way through, and apparently it does. Canada is a national system, federal system. They have 25,000 people under their custody in a country of 30 million people. 25,000 in a country of 30 million. Half of those people are in halfway house situations and other kinds of things. Final thing is, and it goes to my first point, is if the board decisions are arbitrary, if, for example, it depends on which board member you get, so that if you hit the F-man, as you say, your likelihood goes down dramatically. I mean, I've been keeping a record just on an Excel file, which can be turned into an Access file, of all the people who've been released. Done it differently than Judith Brink's done, because I've put it on a file that you can search. And if we knew who the parole board members were for each one of the cases, you could begin to do an evaluation to say, well, this guy has got 6% of people who come before him get released. This person gives 40%. Why is there the difference between those people? I mean, I understand that the reason that the case in Furman, in Georgia, when the death penalty was overturned in Georgia, that it was based on what they called vagueness in the application of the law, and that the law was not applied in a way that you could say there was due process. And I'd be interested, I know a little bit about stats, but I'd be interested with having more information, just trying to get the documentation. I've asked inmates to give me the names of people who were on their parole board members, because you can then start doing it. If you know that they're on the same date, you know all the cases that occurred in that place are on the same date. And you can start searching it. I've been told by Tom Grant, I think, who was on the parole board, that there is a record of this kept at the parole board, that they know. And you have a record of the people? Well, that's what we need. Well, that's all we need. All we need is 2 years, because everybody comes up every 2 years. So if you had that, you could be doing a thing. And if the F guy is doing his work like he's only giving, where he said in the case that I put in the Cure newsletter this past month, was he said, no, this is all about retribution. This isn't about anything else. It's about retribution. So anyway, that's my point.
All right, well, let me say this. Your first comment about, how the decisions are made. There are many parole hearings where if it's a panel of 2 or a panel of 3, they're all involved. A lot of times that happens, like with some of the clients that we get. We try very hard to get a guy to go to the board with the notion that he's got to engage the board. He's got to have something to say. He's got to try to get them to actually, in his case, make a release decision. We don't want them to allow the board to have read the case whenever they read it and just steamroll this guy out of the room. So we say, you got to have an agenda. You got to have a plan. You got to be prepared to talk to the board. You can't sit there and say yes and say no. You got to be proactive on your own behalf. But you don't go into the board telling them you got a lot of remorse. If you're talking about your crime, you got to learn how to discuss your crime with the board so the issue of remorse is covered. And they know how you feel about what you did because of what you said about what you did. You have to do that. But this problem in many of the cases where, and the board has had this problem since I was on the board, where you're getting one board member decisions in the majority of cases. Whoever's up, it's my case, it's my decision. It's not because Eichelberger couldn't get me to change my mind. If Eichelberger was able to pay attention to what I was doing when I had that hearing, if he looked at his copy of the inmate status report because he had a little time, and he thought I didn't see everything correctly or fairly, he could talk to me. But in a lot of cases that doesn't happen. And especially when the inmate's just sitting there like cannon fodder, ain't nothing much gonna happen. Now, I did write a paper. I don't know what I did with it, but I guess I better go look for it again. But the advent of determinate sentences in the state of New York indicated to me, I think quite correctly, that the workload of the board has decreased. So I was of the opinion, basically looking at the California experience and looking at some real problems in our system. We have a lot of people in New York State who come from other countries. Forget about their immigration status for a moment. They just don't speak the language. They have a different cultural background. Things that are okay where they came from don't make sense over here. We Americans are so darn narrow-minded. We only speak English, most of us, not all of you. Some of you can be bilingual. But I'm not. Most Americans are not. We only speak one language, and we only know our culture, and then only a little bit of that. So what about some guy from another country who comes up to the board and is going to be considered for parole release? We don't have anything in the law that says an inmate's entitled to representation by an interpreter. The only thing in the law is a deaf person. That's the only thing in the statute. So you're getting an accommodation if you don't speak English and somebody speaks your language, comes from a local college, is there to help out the board. But you don't even have a right to that. So I said, if the board's workload is going to continue to go down, then we're getting to the time where we have to consider that inmates should be represented at the board. So now we can begin to deal with some of these issues. Now, am I looking to make more money for lawyers? Well, of course. I mean, lawyers do that, you know. So there's more work for us. But there's something in other jurisdictions called counsel substitute. If you've got a guy who's not dumb, but he ain't smart, he's not articulate, he's very shy, he doesn't speak well, if he had an inmate representative who was up to the task, he would be better off before the board. Because he could give the board, this guy knows him, he's been with him, he spent a year with him, and so on. He could help this guy to present himself to the board. It could make a difference. Why are we stuck with one-member decisions? I came on the board September 13th, 1976. 1976. Here we are, the end of August 2012, still talking about one-member board decisions. Why is there no progress? So we need the board to be talking about that. They should be clamoring for the inmates that they have to consider. I want to give this guy a fair hearing. I want to know what's going on with him. You know, if he's not comfortable in this, in my language, in English, what's it about? And then when the cultural difference affects in some way the criminal conduct, how does the board get educated about that so it can take it into account for whatever relevancy it may have? We're talking about whether or not a man stays in prison or a woman stays in prison or they go home. That's a big darn decision. And this business of the Deuce Club is outrageously ridiculous. The statutory maximum is 24 months. You can't give everybody a 24-month hit. You don't tell them what they're supposed to be doing for 24 months. So as the gentleman just said there, he came back to the board 2 years later. Everything was the same. He just did more of what he had done before. The board never says to him, we're denying you because we want you to do this. If they said take ASAT, because he hadn't taken it, I don't use drugs. They told me to take it. Let me take ASAT. They want me to have ASAT, I'll take ASAT. Okay? If they said do something, write a letter to the Pope. Tell me to do something and see if I do it. Give me the opportunity to come back to you after I've done it. Why do I have to wait 24 months? What do you expect when I come back? Most people say, I'll use the same letters I used before. We say, get new letters. You know, it's crazy what's going on. And yet and still, how did they get to 24 months? Do all of you know, any of you know how they got to 24 months? Okay. Okay. Unbelievable. The board used to have to follow their guidelines. The ones that never revised. The guidelines were mandated to go into effect January 1, 1978. So I was there then. Okay? The whole idea of the guidelines was to look at two important factors in the parole decision-making process. One, the seriousness of the offense. Offenses are serious. And two, prior criminal history. The greatest predictor of the probability of parole success is prior criminal history. Is it infallible? Absolutely not. But if a guy's done 3 burglaries and he's in on a burglary, is there a possibility that he'll do another burglary? We got to say yeah. But he may be 57 now. He's too old to do any more burglaries, so we can take that into account. But if he's 27 and this is his fourth burglary, maybe he's going to do it again because he hasn't gotten enough time to dissuade him from giving another shot at the big score. Okay? So we look at prior criminal history because it's a good predictor. How do we get the seriousness of the offense? We came upon it by looking, was there a death? Was there a weapon? Was there forcible compulsion? We look at those factors. So you come up with a numerical score. That's the grid. Now, when you apply the grid to the inmate, when he becomes eligible, and he has served that amount of time, because that began to happen as we moved into the 70s. Remember, the Board of Parole used to set almost all the minimum terms. You guys never even heard of that. The Board of Parole used to set minimum terms. Sentences to state prison were zipped to the max. It was a responsibility of the Board of Parole. When you look at 259I and you look at paragraph 1, you say, what does that mean? The board used to set the minimums in more than 2/3 of the cases. So now, when the judges started setting minimums, because they were mandated to do so, guys would be coming in with a minimum that exceeded the outer limits of the board's guidelines. That guy should go home. So if a board member saw a guy, let's say, and applied the guidelines, but hit him with 6 months, 10 months, stop being an idiot, young guy. You know, clean up your disciplinary history here. Come back and see us. If that guy came back with a clean disciplinary, pursuant to the obligation under the guidelines, he had to ticket out. He was going home. So now, all of a sudden, something emerges in the board. Eichelberger and Hammock were on the panel. They gave this guy a 7-month hit. What a stupid decision that was. I'm not going to sign the release sheet for this guy after 7 months if he didn't do anything bad. Okay? So then you had guys going into court, suing the board, because the guidelines had been applied and now the guy was being held for no reason. How do you eliminate that? Hit everybody with 2 years. Hit everybody with 2 years. So now the guidelines, you can apply them all you want because the maximum hold is 24 months, so they're within the statute. That's where it came from. So now everybody gets 24 months. Is that craziness? But it's accepted. The board accepts it. The board should be saying, it's crazy. They don't say anything is crazy. They just do things that appear to be crazy. I don't know why. I expect more from them. What I would like to see as a parole board obviously doesn't exist. But they should be here with us. They don't come out anymore. They don't come out. None of you have spoken to them. They don't stand up for what they believe. They don't tell you 24 months is an appropriate hit. And let me tell you why. They can't. Why don't they come out? Why should they be hiding? Why are they afraid of you? They're a public body. You see Cuomo, he's elected governor. You see Commissioner Fisher. You see Andrea. Why don't these people come out? I invite them. They don't come to my office.
So I think we have two last questions.
A few points to make, and I'd like to get your responses. First, I'd like to introduce the financial component to the denials of parole. When George Pataki became governor in 1995, there was federal money that was available to states that could show that they were housing their offenders in prison for, I think the number was 80 to 85% of their sentences. And so when Pataki was unable to get the legislature to change the sentencing provisions, instead he gave directives to the parole board, and they started denying people, and in proportion to that denial rate, suddenly New York State started receiving more and more of that federal money. that they could show that they were holding the prisoners. That it was an article that was written, I think it was in the Daily News, which has come up a few times, by Michael Flax. And that was the financial incentive. I wrote an article about that in the Westchester Guardian, where I was a columnist for 5 years. So I just would like you to address that for a moment, if you're familiar with that, before I go on to my next points.
Well, you and I we don't have a disagreement, because some of what you say, I'm sure, is true, but my recollection is this, that it was a Clinton administration, the presidential administration, that said all the states could get money if they agreed to sentence violent offenders or require violent offenders to serve at least 85% of their sentences. When Clinton pushed that and made that money available, Pataki didn't have any trouble accepting it and running with it. So it was back, I guess, in 1995 with the Sentence Reform Act in 1995, which was Pataki's first thing, that we first saw determinate sentences in the state of New York. And remember, it would only apply to a limited number of people. The determinants went to predicate violence. Okay. And then in 1998, with Jenner's Law, which was the second big move from Governor Pataki, we then created all of these determinate sentences. But it was our buddy that we all love, Bill Clinton, who's the one that proposed that. And that's where we got all of this stuff from. However, you're saying more than that, and that's a part of it. I'm not as sure about it as you are, but I'm not prepared to say that you're wrong. It does appear that at the same time we were moving toward determinate sentences, we were getting fewer and fewer violent offenders who were parole eligible paroled, so that the category to look at are our sex offenders. And when you say sex offender in the state of New York, it's a real problem, because in our state we really don't break down sex offenders. We lump everybody in together. And a lot of those people are not the kinds of people that each and every one of us would be a little concerned about because of the nature of what he did or she did. So we got a big fat group, but it doesn't make any difference what they did, even if it's a statutory rape, because the board treats them all the same. They deny them.
In terms of discussing parole, just I'd be remiss if the inadequacy of the appellate process as it relates to parole denials was not discussed. Firstly,
it's a sham.
Yeah, it is, but I want to just share some information for a second, because everyone might not be aware of it. Firstly, if you do go through an administrative appeal, and if you have to do that before you apply to the outside court, there's no attorney that's afforded to the prisoner to handle filing an Article 78 challenge to the parole denial. So I want to point out that's one inadequacy. And an additional inadequacy is that if, as is usually the case, before that court, or even appealing higher up to the appellate division, if the prisoner's appeal hasn't been decided and they're going to reappear in front of the board, then the appeal is dismissed and is considered to be moot, since the only remedy that a court would be able to give, even had they ruled in favor of the applicant, is getting a new hearing. And so a lot of cases get dismissed that way as being moot. And I just want to introduce that inadequacy of the appellate process into our discussion.
Well, I think so far as the appellate process is concerned, I use the word sham. You agreed with it. Yeah. We're both right, and it's sad. It's sad, because the appellate process came into the law, again, January 1st, 1978. And the idea was to give a case a second look. Remember, the max time you could set a guy off was 24 months. So most of the holds were less than 24 months. If a guy did a parole appeal, the idea was to review that and see if there was any reason to continue him to the end of the hold. So if the guy was told to address a particular issue, he had done that in the time that had already elapsed, the guy could go home. What's happened? Why is it a sham? It's not handled by the board. Okay, now 3 members of the Board of Parole, none of whom was involved in the decision appeal, is permitted to sign off on a parole appeal. I've not been there with them. They don't invite me in. But the decisions, all you get in writing, all you get is from the appeals unit. and my understanding is the appeals unit operates out of counsel's office, which is okay by me, I don't care. But it seems to be that their position is not, should this guy get a new hearing, but is there a basis for a defense for what the board did? So the thing that's missing totally from the equation is the discretion of the board. This is an opportunity for 3 members of the board who are not involved in the decision to look at this entire case. The question that I have, and I think I know the answer is, do they look at them? Do those board members who sign off on the appeals read the appeals? My suspicion is they don't. And if they don't, then what kind of a process do we have? We have a bunch of lawyers saying, well, you know, if you don't want to change this decision, you don't have to. So it shouldn't be about the board has to. It should be about whether the board exercising its discretion feels that it's appropriate to.
Last point, I'll be super brief, is I just would like to introduce the innocent prisoner's dilemma with respect to the parole board, in which wrongfully, factually innocent, wrongfully convicted prisoners who have not as yet had success in court, but have completed their sentence minimum, go to the parole board, have good programs, you know, all that stuff. And because they assert their innocence at the parole board, as opposed to taking responsibility, as opposed to expressing remorse, have been denied parole and therefore had their already unjust prison sentence extended even further into the future than was necessary. That catch-22 position is what I'd like to address, and that's happened a number of times, even after having their prison sentences extended through holds, eventually they were cleared. And to me, the rigidity of the parole board in being, A, unwilling to consider, at least as a contextual issue, the possibility of innocence, that's one thing, and then not holding against the applicant the fact that they assert their innocence and evaluating the rest of their application without that in terms of assessing, you know, future dangerousness, success in society, etc. So that was the last point I'd like to make. I'd like to hear a few words from you on that.
Okay. Well, it is a problem for those guys who maintain their innocence. And it's a sad thing that it appears to me, from what I see, that many members of the Board of Parole are of the opinion that if the jury found you guilty, you are guilty. Now, you know, they should know, all of us should know, that in our society, and that's the entire U.S. of A., you're guaranteed a fair trial. You're not guaranteed a correct result. You only get the fair trial. Sometimes you don't, but that's what you're guaranteed by the Constitution, not a correct result. And so what the board ought to understand is they shouldn't be using your denials against you. They shouldn't be saying, hey, you're not showing proper remorse. They should be looking at whether or not you've done the time that was given to you by the sentencing judge after you lost your trial. And say, is there any reason to hold this guy? They're using the failure to show remorse, and they got courts upholding them on it. But the board doesn't need the courts. The board should use its own mentality and say, I don't know if this guy's guilty or not. Why, after 15 years, would he continue to insist that he's not guilty? Is he a lunatic? He might be. Okay, he might be. But what the devil difference does it mean to you as a board member if he's done the time as well as it could be done? Hasn't he now earned the right to your appropriate consideration for his release to the community? Look at his parole plan. You know, what's he going to do when he gets out there if it's all in place? Right? Because you don't know if he's guilty. I'm a lawyer. I represent criminal defendants all the time. The ones who tell me they're guilty, generally speaking, I believe them. But some of them tell me they're not guilty. I may have an opinion one way or the other. It makes no difference. For me, it makes no difference that they're guilty. My job is to represent them to the very best of my ability. If they want to go to trial, we got to go to bat. That's the way it is. But so far as the board is concerned, somebody needs to say to them, you don't understand this aspect of criminal justice. People do get convicted when they're innocent. You're not responsible for determining prosecutorial misconduct. You're not responsible for lying witnesses. You should have concern, though, like all of us should, in eyewitness testimony. I mean, the book is in on eyewitness testimony. And if you as a parole board member look at a case and you find out that the principal evidence against this particular inmate was eyewitness testimony and those eyewitnesses did not know the defendant, you don't have to say he's innocent. You just have to say, did he do the time the way it was supposed to be done? And if he did, I'm not going to hold against him the fact that he wants to hold on to his innocence. But that's not where it's at. That's where it needs to go.
I wanted to just make a quick comment to tie this in with the previous discussion about public defense, because a lot of lawyers have felt that once they got the plea in or the trial is done, they either feel so bad because they lost or whatever, they don't have time, that they don't do sentencing advocacy like they should, including reading the pre-sentence report. And in terms of what Jeff just talked about with no appellate relief, some of the appellate courts have said, okay, we understand, you come before us and tell us that the pre-sentence report is wrong. The judge said he or she would not consider that part that you challenged, so we're not going to give you a new sentence, a resentencing, therefore you don't get a new pre-sentence report, and that bad, the pre-sentence report with the bad information in it still follows you through, and so the parole board is looking at one that some court has said, okay, we'll just assume that what you say is wrong, but the judge said he or she didn't consider it, so we find no harm, no foul, and they completely ignore that. They say you don't have a right, basically, to a correct pre-sentence report at your parole board. If you hear about this, complain to a legislator, do something. And then I have a technical question, Ed, and you can answer it now or you can answer it afterwards. Did the merger of docs and parole, do you know how that's affecting supervision on parole? And have you seen a copy of the regs for how they're now supposed to be supervising people once they're actually out?
Well, parole is still crazy on the supervision end. And when I say that, what I mean is you have individual parole officers who do the best they can. You have individual parole officers who are as lazy as dirt. But you have some cowboys out there who annoy the tar out of people who are subject to their supervision, and they play technical games on you that are really unfair. So I was in court in Manhattan on Friday, and last Friday, and a young man from Legal Aid who's in the Parole Revocation Defense Unit was there. And he's a young man that brought the lawsuit against the board when it comes to the revocation process. And they had categories of offenders based on their crime of conviction in the revocation process. So those who were convicted of crimes involving actual violence were in category number 1. And the way it was set up, an administrative law judge hearing the evidence in a parole revocation case could only recommend to the board what should happen to this guy if he was found guilty. And so this kid lawyer was able to sue and get the appellate division to agree that the administrative law judge should make the decision himself, herself, and the board's out of it. So the board no longer does that. They've changed their regs and so on so that the administrative law judge can make the decision. He was in, and he starts talking. I'm the elder statesman in this parole junk, even though I don't know half as much as these kids do. But he was saying to me, he's got a case right now where they locked this guy up for failure to notify his parole officer of police contact. What was a police contact? He got a speeding ticket. He got a speeding ticket. So why does he have to notify his parole officer that he got a speeding ticket? I mean, what's that got to do with the paroling process? Is he now going to be counseled by his parole officer about going too fast? What if the PO looks at the ticket and he sees he's doing 40 in a 30-mile zone? How does that make him different from anybody else? Whether they get a ticket or not. You know, now if he's going 175 in a 20-mile zone, maybe there's something going up. But that would be the parole officer's inquiry. That would not necessarily be a basis for a violation of parole, especially since it's just a speeding ticket. I just saw in Albany on the way up here on a van, don't plead guilty on a speeding ticket, call this number. And it has a little sign of 55 miles per hour on the back of it. I don't know what this guy does, but if you get a speeding ticket, I didn't get his number for you, but he's in Albany, so you're in Albany. Check this guy out, you know? So when it comes to the parole staff, the merger has not really affected anything. The new risk assessment has. The risk assessment for community supervision is in place. And if you have low risk, you're being assigned to a parole officer who's got a caseload of up to 160 people. So the level of oversight and supervision you're going to receive is low. And then they've got 3 other categories. So the high-risk offenders are in category number 1, but they're supposed to be high risk based on their point score on the risk assessment instrument. But what we say to people who are going to go out, we do a lot of talk with women inmates in Bayview, Beacon, and Taconic. And when we talk to male prisoners as well, you know, the best way to do parole is when the parole officer says jump, you just ask him how high and see if you can handle it. And do your best at it. Because once you develop that relationship with the parole officer, it tends to get reasonably easy, you know? Is that good enough? Okay, Marty. Are we through?
So